Hi everyone. In our earlier video, we discussed the concept of predicate offense under the Prevention of Money Laundering Act 2002. Today we will take this discussion one step further and understand a very critical procedural aspect of PMLA. That is, the legality of arrest under Section 19 of PMLA as interpreted by Supreme Court and the High Courts of India. The series is presented by Synergy Business Advisory Group, Noida, a multidisciplinary professional services firm delivering integrated solutions across CFO advisory, taxation, insolvency, PMLA, buffer transactions, real estate, and legal support to corporates, bankers, developers, and HNI across India. So let us now discuss today's topic. Under Section 19 of PMLA, the Enforcement Directorate has the power to arrest a person, but this power is not absolute. Before making an arrest, the officer must have reasons to believe based on material in his possession and record such reasons in writing. Additionally, Section 19 mandates that the person arrested must be informed of the grounds of arrest and must be produced before the special court within 24 hours. This requirement also flows from Article 22 within bracket 1 of the Constitution of India. Delhi High Court in Neeraj Singhal versus ED, wherein the judgment was passed on 8th of Jan 2024, examined the legality of an arrest made under PMLA. The petitioner challenged his arrest on the ground that the written grounds of arrest were not supplied to him and certain procedural lapses allegedly made the arrest illegal. The arrest in this case had taken place before the Supreme Court judgment in Pankaj Bansal versus Union of India dated 3rd of October 2023, wherein Supreme Court had held that the grounds of arrest under PMLA must be furnished in writing so that the arrested person can effectively exercise the right to legal remedies. However, the court clarified that this requirement would apply prospectively, meaning from the date of the judgment onwards. The prospective application was further explained by the Supreme Court in Ram Kishore Arora versus Enforcement Directorate case. In this case, the court held that for arrests made prior to the Pankaj Bansal judgment, non-supply of written grounds of arrest would not automatically render the arrest illegal, and the expression as soon as may be under Section 19 means communication within a reasonable and predictable time, generally within 24 hours. The High Court clarified the following important principles in this regard. First is written grounds of arrest became mandatory prospectively, that is, after the Pankaj Bansal judgment. For arrests made prior to that judgment, oral communication or showing the grounds of arrest was considered sufficient compliance. The expression as soon as may be under Section 19 means within a reasonable time, generally within 24 hours. Minor discrepancies or typographical errors do not automatically make an arrest illegal, especially when the independent witness are present and the arrestee did not raise objections at the remand stage. Finally, what are the conclusions and our disclaimer? This discussion is purely for academic and informal purpose and does not constitute legal advice. This is CA and IP Praveen Agrawal signing off. Looking forward to seeing you all in the next video. Thank you.